Hello. Good morning. Morning, John. Hi. How are you doing?
I'm good. I'm good. I'm actually a little scared, but I'm great.
Oh, I hope you're not scared about being here because everyone here wants you to be successful. I want you to be successful.
I believe it.
So I'm just trying to get information from probation about how you're doing
Yes.
and see whether or not your probation should be ended. So I'm just going to take a report from them.
Okay.
Yes.
Judge, Judge, there was an extension status report sent into the court for him to be extended a year on his probation. The main reason for the extension is for him to be able to pay his restitution. There was otherwise he's been doing good on probation. We don't have any concerns. The original amount of the restitution was $14,000. He's paid to date $5,238, leaving an $8,762 balance. I spoke with Mr. Perillo. He says he has a plan that he wanted to tell the court, and hopefully it will be acceptable.
All right. So what's your plan?
I found it's taken this long to finally put together in a position with the felony, even though I haven't been convicted, it's still a very good pass, especially at my age.
Yeah.
So with the construction jobs, I get chased off of because I'm just not as young as they used to be.
Yeah.
And it's just taken this long to finally find the job with that on my record, despite that, to earn enough to pay the restitution. And not only that, but I have to take care of my mother. She's 80 years old now, and she has to retire. I mean, she doesn't really have a choice.
Yeah.
So, and that's a good thing that I'm here. So I've done the best I can. When I went to jail, that was the best thing that ever happened. I made up my mind there that I was never going to fall that low. I was raised better. So there's a lot of pride. And my family was important. So I can do it.
All right. So what I'm trying to do is, because there are some cases where everybody has done everything, and I'm like, yeah, there's no need to keep them on. But the reason why your case is extended is because of the restitution. So if you were to pay all of your restitution, then you'll be done today.
Oh, yeah.
But
I'm not trying to avoid it.
yeah, but I know you have a plan. I don't understand why the restitution was so high to begin with. This case wasn't before me when it was from
It
2016.
was a Hill big movie that was on the bench back then, I
Mhm.
think. So
So, I mean, is this appropriate restitution? I mean, I don't understand. I read the report, I read the stipulations. And the stipulation there was, I mean, where is the restitution coming from? And who is the restitution going to? All right, so what's in the PSI? And I don't like to go behind other people's rulings, but what's in the PSI? Is there any documentation, or is it just somebody just said, this is how much I'm due? Because if not, counsel, that may be something that you can look into.
yes, Judge. I agree. I believe it needs to be substantiated. So, no, Mr. Carillo appreciates looking into it to see if that was justified, just to verify it. I understand that. Look into it. Possibly.
And that's what I hear, but I've never seen anything.
There's nothing attached to the PSI for the documentation for that. It's just based on the victim's statement.
All right. So then this is what we're going to do, unless there's objections. Mr. Gerhan?
Yes, yeah.
On this case was done before I was on the bench. It's from 2016. There was restitution that was ordered. It wasn't included in the stipulation, but in the PSI report, they came up with a restitution amount of $18,000, but there's no documentation for that. That's just somebody saying I'm owed $18,000, but no documentation was submitted. So unless there's an objection, because it's really outside my jurisdiction at this late date, but I don't think it's fair for someone to pay restitution if there was no documentation. And it doesn't appear that it was done with his attorney being present, because it wasn't in the stipulations. And then when I read the previous judge orders, well, actually, there's nothing here, but it doesn't appear that at the time of sentencing, that a restitution amount was given. It appears that just in the stipulations, it's in the stipulations. So therefore, this is the amount of restitution. Okay.
Well, Judge, the way I'm reading this is this say $18,088, but it says the actual restitution is 8,000.
So the restitution amount was originally for the bills, I believe, was 14,000,
Yeah.
and then 5,000 has been paid, and then there's a remaining balance of 8,000.
So actually, restitution was only 14,000
14,000.
to an individual, because the
Yeah.
other ones are fees and everything.
Yes.
I mean,
So-
go ahead. I'm sorry, Judge.
And so I'm thinking, if there's no objection, I don't think the defense would have any objections. If somebody can look into and see, if there's some documentation for this other than somebody just saying, this is what I owe. I mean, this is what is owed.
I guess what the state's position would be, Judge, since, don't want to victimize a victim again,
Mhm.
that we would, one, ask, one, if we do have documentation, two, that we reach out to the actual victim
Yes.
and see if they've been made whole from this. Since it is an aggravated assault with a deadly weapon.
Okay. All right. If we can do that, because it appears that there was some mental health issues from what I read in the stipulations. So there were some major mental health issues going on at the time. So then if y'all can look in that, for now, the extension is going to be granted. And then if defense, you come in with information, or probation, if you have information that there's actually no more restitution owed, then the court will strongly consider just terminating because he's done everything.
I think Mr. Guerin had obviously the good idea of reaching out to the complaining witness just to verify that the amount reflected here was the actual amount, and then obviously documentation, and to see what their feelings are as to more amount need to be paid, or if they've been made whole, like Mr. Guerin had said. So I can have my investigator also try to reach out to the complaining witness as well. I know the state will make efforts too, so we can hopefully reconvene and hash this out as to what perhaps needs to be owed.
My only fear is, this is coming up on 10 years old.
Oh, yeah.
And victim, may have not kept documentation if it hadn't been turned over. So that's one of my concerns.
All right.
Maybe we can work it out, see what maybe she would be wanting, something less than 8,000, or if she wanted 8,000.
All right. So it'll be extended. And then whenever y'all want to put it back on the docket, it can come back on the docket.
Okay, good.
And extend it for a year. Okay. All right. Thank you.
Good morning, Your Honor. John Robertson from the Holmes.
All right. Are you all ready to proceed on this motion to revoke?
Yes, sir.
Can I have a motion to revoke stamp, please?
I don't need it. I'll have a digital copy.
Second.
Yes.
What first conversion?
Court is calling 2024 CR 2336 State versus Larietta. Nicole Holmes, could I have parties announced?
Andrew Harris Ailman for the state.
John Robertson from the Holmes.
And are you Miss Holmes?
Yes, ma'am.
Are you the same Larietta Nicole Holmes who was placed on deferred adjudication in 2024 CR 2336 for the offense of injury to an elderly person with bodily injury on June 13, 2024 for a period of 2 years? Is that you? All right. You're going to have to make sure you keep your voice up so that I can hear and the court reporter can hear. State?
In Bexar County, Texas, the defendant Larietta Nicole Holmes did then and there fail to report to the supervision officer as directed for the months of March and April 2025 in violation of condition number 4.
How do you plead to that? True or not true? State?
State waives the remaining violation allegations.
Any objection to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? All right, so here's the thing. You're going to have to speak up. And you need to speak the way you speak when you're not in court before me. So whatever agreements you think you've worked out with the state, I don't have to follow that agreement because this is a contract and it's a contract with the court. It's not a contract with the state. It's not a contract with the defense. So you pled true to violation of condition number 4. Regardless of what agreement you think you've reached with the state, I can revoke you and sentence you to 10 years in prison. Do you understand?
Yes, ma'am.
All right. Knowing that, do you still wish to proceed with this plea of true?
Yes, ma'am.
All right. Is there a proposed agreement?
Yes, Your Honor, to deny the motion, continue on regular supervision and amend for the following conditions. Immediate placement of GPS monitor for 6 months. Proof of residence or proof of employment with every OV. Don't know what OV stands for. If no proof of employment, then proof of disability. If not on disability, 4 job searches per week, as well as minimum of 12 community service hours performed monthly. Immediate enrollment in anger management course. IVR call inline for 4 months. Bi-weekly reporting for 4 months.
All right. So here's my question. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Larietta Holmes.
What have you done since you've been on probation?
Since I've been on probation, I did try to finish my classes.
So you didn't finish your classes. You tried to. All right.
For community service, because last time I was here, my lawyer asked if I could use, I was getting my BA,
Mhm.
and he asked if I could use that for community service.
And why didn't you finish that?
A lot in between the time happened, so I did have to drop.
What has happened?
Lights were turned off in November, and it was hard for me to try to get any type of assistance for it because it was overdue and they just turned it off. So in between time, I was trying to find assistance, I was trying to find work, and also trying to maintain my home, and keep up with everything that I could, and also raising my 2 children.
So where are your children now? Who's raising them?
My son, he's with his girlfriend, and my daughter, she's with my sister. She works, my son works. Both of them work, they're both of them in school, and they both get good grades.
Okay. So here's the thing with lights being turned off. Back in the day, people didn't have lights. You turn on a candle. And people always assume that where people are in their station in life is always where they've been. Like they never had financial problems or things happen. I've had my lights turned off before. And you know what? My mom and my grandmother would always say, hey, whatever you do, make sure that you have if you're living in an apartment, make sure that's paid. If you're living in a house, make sure that paid. If the lights get turned off, if the water gets turned off, at least you'll always have a place to stay. So getting your lights turned off, and sometimes people are like, oh my gosh, that's so embarrassing. It's like, I still have a place to stay. Getting lights turned off happens to everybody. I guarantee you, a majority of the people in this courtroom, attorneys included, deputies included, court reporter included, have at some point had some utility turned off. One time it happened to me, and it's just because I forgot to pay the bill. And I'm like, hey, why is my water not on? And they said, Stephanie Sauce came out and turned it off. I'm like, oh my gosh, I forgot to pay my bill. And they came out and turned it back on, of course. But that's nothing to be embarrassed about. So, and the reason why I'm telling you this story is because you have to reach out to probation and tell them what's going on in your life. Otherwise, you could go to prison for 10 years.
Yes.
And then who's going to be taking care of your children?
Mm-hmm.
Now, what's happening with the new number 1 in this case?
Judge, I can elaborate on that. That is an allegation based on a voicemail that was left with the landlord. I received a copy of the police report. The landlord sent a copy to the court, and that was forwarded to me by Norma. They took a police report based on a voicemail. And last time I looked, a voicemail doesn't arise to a Class C threat.
What?
So anyway, that'll have to be sorted out. I think that's obviously one of the reasons why we're not going on that today.
All right. So what's happening with this number 1?
That's a municipal court problem.
Okay.
So
All right. Probation. What is your recommendation?
judge report summary, according to the judge summary, is exactly what Mr. Edelman states.
All right. So why were you not reporting? That's the easiest thing, to pick up the phone.
I was communicating with my probation officer. I was
Not in March and April.
I was in March and April. I did. I even got kind of scared because he wasn't responding back to me. He never did tell me to come in. Everything that I was going through, far as dealing with the landlord and also dealing with housing, and my life still been not connected. I was communicating with him.
So has she been communicating?
Judge, I can check the notes.
All right.
That's one thing we discussed, judges, that communication, however the communication is not a substitute for reporting. And I think Larry understands that.
And my lawyer did make a good recommendation. He's when, communicating, texting, sometimes it's best for me to go down there. And I didn't know that. To set up an appointment, go down there so I could be seen. And that way it wouldn't be no miscommunication.
Last office visit is a system indicates February 28th, 2025. There was a text message sent out with an appointment scheduled in March. I don't see anything indicating there was a phone call with that was just the officer, and the same for April, Judge. There were also system text messages reminding his Holmes, you need to pay your fees. There's some batch emails that went out for services.
All right. This is her first motion to revoke. I'm going to tell you something, and I'm going to tell you right now. Number one, when your utilities are disconnected, that's nobody's fault but your own. If my utilities get disconnected because I forgot to pay, that's not their fault. It's not the utility company, it's my fault. Your emergency is not somebody else's priority unless they want to make it their priority. And when you have a landlord and part of your contract with your landlord is you pay rent and you pay utilities, when utilities get cut off, that means that you didn't pay them, or maybe the utility company made a mistake. If the utility company made a mistake, then they will come out and correct it. Now with CPS Energy, if they do that, they can turn it on immediately because they've switched out everybody's meter where they can operate it from in office. But when your utilities are cut off, one thing you do not do is on your own try to cut them back on or tamper with meters or anything of that nature. Do you understand?
I would never do that. I don't want to.
No. Okay. Here's the thing. Don't say that because that's what's in the police reports and everything. And the other thing is, it is clear from the court, based upon what you're on probation for, that you do have an anger issue. And it appears from the court that you don't know how to address your angers when things don't go your way other than lashing out at other people. That is going to stop. Otherwise, you're looking at 10 years in prison. Then the 10 years in prison, you can try and lash your anger out at other inmates. And you know what's going to end up happening? Somebody at the prison, somebody at the jail is going to be badder than you. And they're going to unleash anger on you. So if you don't want that to happen, then you had better change your ways. And this bullying thing that maybe you're doing with people that are older than you because you're on deferred adjudication for injury to the elderly, that's going to stop. And your landlord says that they're 57 and they have a disability and they're having to deal with you. So if you were living at that property, you don't have to worry about not having lights at that property because the court is no longer going to allow you to live at that property and you're no longer going to be allowed to have contact with her. If you have contact with her, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
See, and I don't know why you're giving me that attitude now. You know what you did to Miss Holmes, that breathing hard. No, that breathing hard thing. Yes, ma'am. Yeah, that's not going to be tolerated here. Do you understand?
Yes, ma'am.
It's time for you to start showing respect to people, whether you think they're worthy of it or not, because you're landlord. Whether you think they're worthy of it or not, you need to show respect to them because you're living on their property in their house and they can take that away. Do you understand?
Yes, ma'am.
And you need to start behaving differently so that your children will know the proper way to communicate and it's not through violence. Do you understand?
Yes, ma'am.
All right. So you're going to start completing the conditions of your probation immediately. And when you are released, if you don't start enrolling in these programs and completing them, a motion to revoke is going to be filed. Do you understand?
Yes, ma'am.
All right. The court will deny the motion. You need to get items. You'll need to have someone other than yourself go over there and go with the police escort to retrieve your items. You are not allowed to call her or have third parties call her or have third parties contact her, other than that one time when that person goes to the location, if you have items there and they need to go there with the police escort. Do you understand?
Yes, ma'am.
You're going to start your anger management classes and probation. What is the earliest she can start anger management?
Give her 30 days.
All right, anger management class are to begin within 30 days. Do you have a disability?
No, ma'am.
All right, she doesn't have a disability, so there needs to be there's no proof of disability needed. You're going to need to get a job. That's how people make it in this world. Nobody's depending on somebody else to pay their bills. You're going to get a job. And if you need to get 2 jobs to make a full-time job, then that's what you're going to need to do. So I'm going to require a full-time job. And for the court, full-time employment means at least 40 hours a week. If you want to get 2 part-time jobs, 20 hours each, that's fine. But you're going to work, and there are plenty of places for you to find employment. But sometimes people think certain employment is beneath them. No employment is beneath you because we all need doctors. We all need people who are going to pick the fruit. We all need people who are going to work at HEB or work the fries at McDonald's. There's no shame in that. It's a legitimate job. So proof of full-time employment within 45 days. And GPS, probation, do you want GPS?
Yes, ma'am.
All right, there's to be GPS, waive fees. Do you want full-time GPS tracking? What do you want? All right, partial GPS for employment. And GPS is until further notice. And do you still want this IVR hotline?
That court summary indicates she shall submit for UA.
Why are you not going in for your UAs?
To my knowledge, I only felt one that was in.
Why are you missing one? Because when you miss one, you could go to prison for 10 years.
I think the day that I missed that was when I went to the office to see him. And by the time it was time for me to leave to get in my Uber, they were going to be closed. And I think it fell on a weekend.
All right, probation, do you still want the IVR hotline? All right, monthly UAs. You're not to miss a single UA. Do you understand?
Yes, ma'am.
Probation, is there anything else?
Do the bi-weekly reporting for 4 months, Judge.
All right, bi-weekly reporting for 4 months.
Nothing else, Judge.
Is there anything else you need from the court in order to be successful?
No, ma'am.
All right, you better do better. Otherwise, you're looking at going to prison for potentially 10 years. From here on out, we can go off the record. From here on out, anything that you do, you need to ask yourself before you do it, is this something that could result in me potentially going to prison for 10 years? If the answer is yes, don't do it unless you want to potentially go to prison for 10 years. If your answer is, well, maybe it could, don't do it because you could potentially go to prison for 10 years. Do you understand?
Yes, ma'am.
All right, good luck to you. Thank you,
Thank you.
counsel.
Results. Hello,
Hello, Mr. Washington. How are you doing today?
Pretty good.
All right. The court is calling 2025 CR 002917 State versus Patrick Washington. Can I have parties announced?
Andrew Harris Edelman for the state.
Marshall D. White to Mr. Patrick Washington, defendant, Your Honor.
And are you Mr. Washington?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Counsel, I'm sorry. Mr. Washington, have you reviewed true bill of indictment?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, proceeding on the lesser included Class A deadly conduct.
Any objection?
No objection, Your Honor.
The court will find that the state is in compliance with discovery. Mr. Washington, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on the lesser included offense of deadly conduct? It's
Yes,
a Class A misdemeanor. It's up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yeah.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Washington, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am. No, yes.
Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of deadly conduct. Your punishment is to be assessed at 306 days in the Bexar County Jail. There's a $1,000 fine and no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
That's correct. Yes.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions? Outside the agreement, the state is saying that you're not to have any contact with Mr. Michael White or his residence. Did you understand that?
Yes.
Those are recommendations from the state, and the court does not have to follow those recommendations. Did you understand?
Yes, Your Honor.
Then to the offense of deadly conduct, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Should be contained in Exhibit 1 and attachments, Judge.
No objection.
All right. State, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
No objections here, Judge.
All right. Anything you wish to say on behalf of your client?
Yes, respectfully, Judge. Mr. Washington understands the situation here. He apologizes to the court for any delays and trouble that he may have caused. He wants to get back, to living his life and this type of thing. He's told me that it's not going to happen again, and I tend to believe in Judge. I think Mr. Washington is going to come back out, and I think going to be a law-abiding citizen like he has been for most of his life.
All right. So, Mr. Washington, this is what the court will do. The court is going to order
Yes, Your Honor.
there's to be 306 days in the Bexar County Jail. credit for any time served. There's $1,000 fine, time and money to run concurrent. Is this a judgment
It
satisfied?
should be, Judge. If the court can do so, Mr. Washington would appreciate it very much. He does, I believe, have 155 days in.
If it's just 155, they'll have to calculate it. What I can tell you at the jail, if you have not caused any problems at the jail, they'll give you 2 for 1. So every day that you serve, you will normally receive 2 days. But I don't have any control over that.
Can you stipulate I get 2 for 1?
No, I'm not allowed to do that, but the sheriff does that. But I'm going to give you credit for any time that you've been in jail. And what I can tell you, normally, if you have not caused any problems at the jail because the jail is overcrowded, they'll give you 2 for 1. Okay. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes,
Did you understand it and sign it?
yes,
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal, okay?
yes.
All right, we can go off the record. Do you have a place to stay? Or are you homeless?
They working on it in the jail about giving me a housing program at the Haven for Hope. I
He
talked
was
to
on this.
them. I appreciate if you can get the mental health or whoever concerned about the discharge to help me get the program, one of the programs.
Well, I will tell you, and I know your counsel could probably help with this. They have a place in San Antonio, and I just toured the facility. And it's called Twin Village.
Yeah.
Now, in order to apply for their housing, you'll have to go through the city. But council, it's called Twin Village, TWIN Village.
Write it down. Right.
And what they do is, even if you're not able to get a house there, they actually have places where they would take people in to at least give them a hot meal and let them be able to shower and have access to wash their clothing that they have, okay? But they do that through the city. That's how you're able to maybe get one of those homes. They're tiny homes, but they're beautiful.
Yeah.
Okay?
You got a number or anything like that, Judge?
Just 1 second. Let me look at that. Oh, so I think this may be a number you can call. 210-361-4322. At least they'll put you on the right track.
4332.
4322.
Thank you.
And it's located on the east side, but I think they're going to try to build more throughout the city.
All right.
And if for some reason you can't find a place to stay or something else is going on, if I'm still here, you can always come back here and we'll see if we can help you with the place.
Yeah, well, I can come to the courthouse and
Yeah, you can come here. If I'm still here, I'll look through and see if we can find a place for you. And also, council, they do have the community court. It's right next door with Judge Barra. They may have some information. Let me see. Does anybody have one of those booklets that have the treatment course listed in it? Oh.
This is what you're talking about?
Oh, no, not this booklet. It's the one with it should have the list of the treatment court that Judge Barra has. They may have a pamphlet over there that you can. Oh, yes. And if you'll, Mr. White, the information should be in there.
Right. We'll sit down in the box if good for a minute.
Sure.
We'll see what they have.
All right. Thank you so much. Good luck to you, sir.
thank you.
Yeah.